The production of this program is made possible thanks to the support of the following and viewers like you. Cowichan Tribes v. Canada has rapidly become the most significant land title case in Canada and possibly in Canadian history. It has sparked intense and competing arguments in private, in public, and in the Legislative Assembly in Victoria. Premier Eby was grilled mercilessly about his defense of private property rights, his government's slow response to file a stay, and what the decision means to homeowners. Tensions flowing from the decision reflect the need to recognize that while Indigenous nations are entitled to seek recognition of their constitutionally protected rights, there is also a need for fee simple owners to maintain certainty in title. Central to this tension is that the law may not allow for commercial title and fee simple to coexist on territory under First Nations ownership. During the case, the impact on private property rights was recognized, to which the court invited the parties to inform fee simple owners to be notified. All parties decided not to inform private land owners. I invited Radha Curpen and Junger of McMillan LLP to join me for a conversation that matters about the Cowichan case and its implications to landowners in Richmond and quite possibly the entire province of British Columbia. Robin, Radha, welcome.
Thank you.
Thank you for joining me. Robin, maybe I can ask you to start by giving us an overview of what the ramifications of this case could be, and then let's talk about how we got to here.
Sure. There's a lot of different potential ramifications of the case, but the biggest issue, the one that's been getting the most attention, is what does it mean for private property owners? And in particular, what does it mean for private property owners that hold lands where the court has now in Richmond found Aboriginal title to coexist over their property? Are they really the owner anymore? Are they the full owner? What does this mean? It's never been done in Canadian history where a court has ordered Aboriginal title over fee simple land. And there's just a lot of questions that come from that. The court has also expressly said that the provisions of the Land Title Act that provide certainty, guarantee that when you have title to your land, you own it. Not so much. Not so much. You own it subject to these Aboriginal claims. And while this decision made factual findings about fee simple lands only on I'd say 800 acres or so of Richmond, the principles have application throughout British Columbia. Much of British Columbia remains subject to claims of Aboriginal title that have not been sorted out. People will have seen in the media, for example, an outstanding claim over the entire city of Kamloops, among other areas. And I think it's raised questions about how is this all going to play out and what does it mean for private landowners? Because I think, most British Columbians certainly support reconciliation. But if it means uncertainty for their land title and potential impacts on borrowing and land use, it just instantly gets a lot more complicated for everybody. And I should add that there are other provinces in Canada where Aboriginal title claims remain outstanding. So it's a very big deal.
It certainly is. Radha, so let's go back. This case is one of the longest in Canadian history, more than 11 years. And it didn't set out to seek this kind of judgment. It was really about fishing rights on Lulu Island. But what happened? How did we get to this point where what the ramifications of the decision have become so monumental?
Well, the plaintiffs sought Aboriginal title on the lands, what we now call the Cowichan title lands, actually for much bigger area than the ones that they got. So, and that area included also private property owners, the federal government, the port. So it's not just they sought that. They sought Aboriginal title on the land.
There was even or water rights or land submerged underwater.
Submerged lands as well, yeah.
And initially they were basically saying we have the right to that land, but the intent did not at that time appear to say we wanted to extinguish ownership of fee simple property.
They did not do. They did not seek to invalidate private property owners, but like ownership. But like Robin said, they ask for Aboriginal title on the entire land. And what does Aboriginal title mean? And the court went on and explained what it means. And it says it coexists. And it says the indefeasibility of title under the Land Titles Act, which is the guarantee that when you see your name on ownership, that it means you own it. You own it completely, subject to obviously laws of general application and all of that, but you could rely on it. You could go to the bank with it, and people do. So that is what happened.
So, Robin, with this ruling, though, if this holds up through appeal and then probably ultimately to the Supreme Court of Canada, what does this mean about who ultimately has title? Will it be the First Nation that winds up being the title owner, and that the province of British Columbia no longer has the authority to grant fee simple property rights?
Well, that's the nub of the issue. So here you have the court saying that Aboriginal title can coexist with the fee simple title for the private owners. Maybe if it's all right, I'll take a step back and just talk about the different categories of land here and what was sought and what happened. So you've got some federal Port Authority and Richmond lands where the court found Aboriginal title and said those lands, that fee simple title is invalid. It shouldn't be there. Effectively, they've got to give up the land. The court suspended that for 18 months, but they made that very significant ruling. You got to give up those lands. Your title is invalid. With respect to the private property owners, there's dozens of homeowners and small businesses, and we act for one of the significant businesses in the area. With respect to those, the court did not go so far as to declare the fee simple title invalid. Fee simple just means private property, what you own when you own a home. The court did not go so far. It wasn't asked to go so far in relation to those properties. But it did still find that Aboriginal title and fee simple coexist, and that raises all kinds of questions, and I'll tell you why. Because when you own a home, you have the right to use it, to possess it, to get the economic benefits from it if you rent it out or whatever. Well, the definition of Aboriginal title is also the right to use the land, to choose the use to which it's put, to get the economic benefits from it, to the exclusive occupancy of it. So as I've said before, I have no idea how Aboriginal title and fee simple can coexist when they both give exclusive rights of possession. It doesn't make any sense to me. So in any case, that will be sorted out in due course, and that is a big part of what has to be litigated further.
The production of this program is made possible thanks to the support of the following and viewers like you. One of the issues that I have trouble trying to fully comprehend or understand is that I believe it's sui generis is kind of the ruling under which the First Nation has the right to the land. But what that means is that they, as a collective, have that right to the land, and therefore, as a collective, they don't have the ability to assign individual rights.
Yeah.
But with this ruling, does their title supersede that of the province? And is this where we wind up in a situation where we're going, well, who has the right to give that fee simple authority to especially people who have invested in this in these properties?
Yes. Let me start, and then Robin can continue. So on the title, you're absolutely right. It's a unique interest, sui generis, and it's a community interest and not individual. And it can only be transferred to the Crown. It cannot be transferred to others. And that's part of the law to date. So that is the difference. And it is also, from what the the judge said it is a senior interest. So you're right. It's a prior and senior interest. That's what it says, and you can't transfer it Aboriginal title. And the other thing is, and Robin touched on it, and I think you may have asked it with that question, is the fact that laws of general application apply to fee simple ownership. Laws of general application do not apply to Aboriginal title lands unless they are justified. So you have to go through a process of justifying why they do apply or not. So from the perspective of understanding that issue, I mean, apart from the indivisibility, there's the issue of application of laws, and there's the issue of, and Robin touched on it, what the uses you can make of it. So we both have exclusive use, both are entitled, and in fact, the court even said, I think, that the validity of the fee simple owners remain until it is challenged, right? So something like to that effect. I'm paraphrasing, and until it is challenged or until it is reconciled, is something that was said. And maybe Robin wants to add something to that.
Yeah, to me, the most important thing, and what do the viewers care about, is what's it going to do for home ownership and the economy of British Columbia? Can people get loans and have business certainty and invest in this place? And I think it's raised a ton of questions, particularly on private property. Private property is the bedrock of our system. As soon as global investors and others start saying, wait a sec, you kind of have private property, sort of? Well, explain to me the caveat. What do you mean by there's a caveat? And then you have to launch into a fairly egghead debate about legal nuances in the unique Aboriginal law of Canada. It's problematic. So really the issue here is, how did this spill over from a dispute between the First Nation and governments to sweep in businesses and farms and homeowners? That's the question. So yeah. I can speak to that if you like, because there's a bit of a history to it. Yeah. Yes, so in 2016, when this case was just early on, not even at trial yet, the government of Canada went to court and said to the court, this claim includes private property. I think you should direct the Cowichan Tribes, the plaintiffs, to give notice to the private property owners so they can participate because they may be affected. The Cowichan Tribes opposed that. The court said, well, they're not looking to kick people off their land, at least yet, the private property owners. So we don't need to hear from them yet. I think that was a huge mistake, but that's what the court ruled in 2016. So fast forward, the trial happens in the early 2000s, ends in 2023. Judgment comes out in 2025, and it's got just the briefest of mention of the private landowners in paragraph 44. And it says, that they don't seek the same declaration to invalidate the private lands. Okay, well, so be it. But isn't there still a huge impact here on private landowners and businesses when someone says there's Aboriginal title, you're a co-owner now? And this is not me speculating. The court itself, after having said, don't worry about the private landowners, goes on to say that the exercise of Aboriginal title in fee simple can coexist, but they may not be exercised in their fullest form. The exercise of either will require a modification of the other. So wait a sec, the court's saying, I've now modified your fee simple rights. You still got them in principle, but I've modified them, I've limited them. Well, how have you limited them? There's no answer to that, but I have limited them. It's created this tremendous uncertainty, and it needs to be sorted out. And I don't think anyone can go through this decision and make full sense of it or say, well, if we just, interpret it this way, we'll be fine. It's created a huge, huge sense of uncertainty. So there's two paths out there now to try and fix this. One is the appeals. And separate from that, there's an application pending. Our client has publicly announced that they intend to make an application to reopen the case at the Supreme Court level, essentially part do-over, and saying the private landowners, at least our client, should be heard before any decisions are made that affect the private landowners. It's the private landowners and businesses being swept into this that has caused all the concern.
Yeah, and the third path as well, if I may say, is that there is a potential, we don't know whether this is going to happen, of a constitutional law reference to the Supreme Court of Canada directly by the federal government. It is something that some people are asking the federal government to do. We don't know whether they would. But also, don't also forget that the court decision is not stayed yet, and so
that
therefore,
application hasn't been filed by the province, has it?
I haven't seen it. I don't know, Robin, whether you have, but I haven't seen it. So in the meantime, the court has said go ahead and reconcile. So that is also problematic because we need to understand what are the guardrails around this, and what are there are significant implications for all of us. Yeah.
Well,
So-
Mr. May I jump in on this? There's a lot of discussion about this stay issue, and the Premier Attorney General jumped out very quickly. I mean, they announced an appeal of this decision over the weekend. I've never seen that in my career. So obviously they're very well aware of the political sensitivity of this case. And so we're going to get a stay. Well, okay, stay. What are you going to stay? Are you going to stay the order that's already suspended for 18 months on the Richmond lands? Are you going to stay the order, the declarations related to the fee simple lands? What's that going to do? Will the bank say, oh, well, it stayed for 14 months, so I'm going to give a 30-year mortgage now? I don't know how you can suspend, have an injunction against investor concern. And a stay is not going to change the language of the decision unless and until the decision is changed or appealed. I myself, I just don't see how a stay is going to solve the problems that people are facing.
Yeah, the stay doesn't solve the uncertainty. Absolutely not. I mean, that train has left the station, and so people need to understand what is it that what kind of certainty can you bring? What are the guardrails so the stay itself doesn't?
The production of this program is made possible thanks to the support of the following and viewers like you. So much of what has changed in Canada's relationship and British Columbia's relationship with First Nations over the past number of years, going back to Delgamuukw and maybe earlier, all the way back to Sparrow, is that the landscape and the rules have kept changing because of court decisions. And now we're in this very, very interesting and new territory about, Robin, the appeal that you're making to the Supreme Court. Is it time now for legislators to say, okay, we actually have to have that frank and honest discussion about what this relationship is going to be and how do we actually work towards true reconciliation? Because if we can't resolve this in the courts, then what other recourse could there be? Because if you suddenly say to everybody, well, as you pointed out, yeah, you have property rights, kind of, maybe, we're not sure, therefore you don't have certainty, well, then even as an individual homeowner, I don't have an asset that I can go and borrow against when I want to improve my home or start a business or whatever. Mm-hmm. Like, it's a very, very tenuous situation that we could find ourselves in.
Yeah.
So the idea...
Well, go ahead, Robin.
Yeah. The idea of let's just get the government to come in and fix this may be appealing on the surface, but it's got a couple problems, big problems. First of all, these are constitutionally protected rights, and the case law, the government just can't pass a law overriding it, even if it was willing to. It doesn't work that way. It would be illegal. But also, the negotiations that are undertaken have to involve some very, very complicated issues. I used to be a chief provincial treaty negotiator. When we would negotiate treaties, you'd have hundreds of pages of detail about which government, including the First Nation government, can pass laws on which issues and which people where, who gets the tax revenue, who owns what happens to private parties. Private land would never be swooped into that. It was a very clear and certain regime. If you look at the Tsawwassen Treaty, You look at the Manolt Treaty, there's more coming. They're very sophisticated and comprehensive. Short of a treaty, what is the government going to negotiate? I think one should be very careful and worried about that. The last thing that I've seen the government negotiate in this context was a deal over Haida Gwaii. And they acknowledged Aboriginal title over Haida Gwaii after having told the court, by the way, that the two fee simple and Aboriginal title could not coexist. The government saw fit after the trial ended to nonetheless sign the Haida agreement. And our client's recently written the Prime Minister on this issue saying, look, if anyone's thinking about a Haida type solution here, you better think again, because the Haida agreement doesn't deal with many of the fundamental questions, including what laws apply to. Does the Builders Lien Act apply here on Aboriginal title lands? Good question. What about the Environmental Management Act? Good question. Nobody has answers to these. So I think unless there's going to be a comprehensive Aboriginal treaty negotiated to solve this stuff, it's really going to have to be for the courts to fix, not the government.
Yeah, I would say I agree with that, because most, let me put it this way. Most of us are for reconciliation with Indigenous people. So it's not about that. It is about what are the guardrails in terms of making sure that there has to be proportionality between between Aboriginal title and fee simple property. They have to be able to not impact, Aboriginal title should not impact fee simple. So reconciliation can be done in a way without impacting fee simple, and I agree with Robin about the Haida Gwaii agreement. It cannot be like it says coexistence again. At the same time that the provincial government just went to court to argue, saying that there should be coexistence. Then they did that. There has to be some consistency in terms of what we're doing, and also for people to feel that there is going to be certainty. We have to be able to live in a society that has laws that is predictable, that is stable, that is knowable, so people can conduct their affairs. They can't. That's words that the Supreme Court of Canada has used in the past in explaining the importance of our Constitution. So we have to look at as a Constitution as a whole and find a way forward. But like Justice Lamere said, we are all here to stay. So I think that's what we need to do.
So, Robin, did the province have a fiduciary responsibility to protect the property rights of individuals and companies? And if they failed to do so, does that make them liable if all of a sudden ownership becomes in question or is denied?
Well, it's a very complicated question. I'll probably stay away from that somewhat because we're acting for one of those parties. You've probably seen in the media there has been a class action filed, recently. Irrespective of the legal claim, I guess the question becomes, what are the obligations and what would one expect of a government when you're representing the public interest in this litigation? So there's an important point that needs to be made here. When this trial was brought forward, the federal government at the time argued that Aboriginal title was extinguished on the private property. When the fee simple was granted, it was extinguished. The word extinguishment doesn't sound super nice, but it's a doctrine known in Aboriginal law all the way back to Calder in 1972. And the federal government argued, the fee simple titles, they extinguished Aboriginal title. There's no more Aboriginal title there. Even if the case is made for Aboriginal title, it's not on the private land. Well, around that time, the federal government under Attorney General Jody Wilson-Raybould put in some litigation directives, or was developing litigation directives to say, we're not going to make that argument anymore. We're not going to make that argument anymore. So they amended their claim, took out that claim, the defense, and said, we're not going to rely on that anymore. British Columbia did not rely on that at all. And the court itself said, while Richmond argued this concept that Aboriginal title was extinguished when private land was created, neither the federal government nor the BC government argued it. So imagine you're the court and you've got a local government saying, the province extinguished Aboriginal title on these fee simple grants. And the province is sitting there and saying, well, No, nothing to add, nothing to say. I don't have a position on it. So this is going to be a big issue on the ongoing litigation. Is the government of British Columbia and the government of Canada going to step in and make this argument? Because one would think that the governments should be making all possible arguments in the public interest. I also want to be clear and candid that the question of whether the province could have extinguished Aboriginal title is one that people debate, and it's complicated, and there's arguments that can be made both ways. It's much richer than just, well, in 1997, the court said the province can't. It's more complicated than that. But what I can tell you is this: neither government was arguing it. They're not even arguing it. So I don't see a way to really resolve this unless the two governments come to the litigation, being prepared to make all possible arguments in support of the public interest while still fully respectful, of course, of Aboriginal rights.
Yeah, and I would say that constitutional law cases look at context. And I agree with what Robin said about extinguishment and the issue of when and who has jurisdiction and when extinguishment occurred. Did it occur prior to the union and all of that? That issue has to be fully put in front of a court, and fully the legal imperatives around that issue has to be really looked at. And within the context of now we're looking at fee simple, like ownership. So again, we're talking about a country, a constitution. The constitution the case has to fit within the constitution. It has to work. So there's a lot of constitutional principles that should come at play here, and should be really considered by a court. And it should also be argued in that fashion, in addition to everything else.
There's a lot of uncomfortable conversations that are going to take place as a result of this, because there is a tendency to want to label anybody who does not want to fully embrace Aboriginal title or where we're moving as being either racist or revisionist in history. Yet we're in a very interesting intersection at the moment where if we don't have frank conversations, where we take some of that rhetoric out of the equation, it's going to be difficult for us to find agreement.
Yeah, we have to speak up in the sense that I can say personally, and I can say Robin can speak for himself, but we are for reconciliation. In fact, some of the things that I've done in the past is talk about our role in reconciliation, because we each have a role to play. And so there is no issue about that. I'm also for making sure that our country works, our constitution works, and that Aboriginal title and reconciliation should be done in a very good way that look at the rule of law, legal certainty, proportionality, all of those constitutional principles that are important. So in order for reconciliation actually to work, so that it does not undermine reconciliation. So we do want that. So I do want people to speak up, have the frank conversations, have the difficult discussion, and talk about it so that we can get through this. We have to be doing this all together, and like we are all in this together. But I am, as Robin says, I am also uncomfortable allowing government to go and do side agreements where there's no transparency, where property rights are being impacted. And I do not think that's the kind of society, that the kind of country we are.
No, there has to be transparency, and these conversations have to take place. Not that you can do it devoid of emotion, but it has to be done in a manner that allows for respectful exchange of ideas, and find that path that allows for all parties to be able to coexist and continue to support and build our economy. And when you talk to many First Nations, they are equally concerned about the ability to do this.
And frankly, when you think about the economy and the potential impact on the economy, it is not in the interest of Indigenous people, and it's not in the interest of reconciliation and economic reconciliation if you have an economy that's not working.
The production of this program is made possible thanks to the support of the following and viewers like you. So, Robin, what should we be looking to in the coming months? Because as we wait to see where we wind up going through an appeal and ultimately towards the Supreme Court, what should viewers be aware of from your perspective, and be, ever present about how it may impact them?
I think this question about land title certainty is fundamentally important. Even if you're not a landowner, you're still affected by this. It affects whether people are willing to invest in rental housing. People are willing to build more housing. People are willing to build a factory that will employ hundreds of people. And you need certainty. I know the Cowichan Tribes representatives have said, we have no intention of kicking private property owners off their lands. They should all, relax a bit. Well, that's good to hear, but that is not the certainty that the system requires. So we need to focus on getting certainty. That's what people want. They just want to, be able to support their families, go to work each day, have a healthcare system that's properly funded, proper education. That's what people care about. And that's why this matters to everybody, in my opinion. In terms of specifically what they should watch for, I believe the most immediate thing that is worth watching for will be the application to reopen the Supreme Court decision. I know that sounds a bit atypical, but until a final order has been entered into, a judge has the ability to reopen the case and hear further on certain issues. So, our client's going to make that application soon, and it'll be up to the judge to decide whether to let that happen or not. It'll be up to the judge. But, we hope the answer is yes. If so, we believe that could be a very good opportunity to get these issues back before the court where they need to be and sorted out sooner rather than later. Beyond that, there's the appeal, and, that's going to take years. But I think it's extremely important for everybody to recognize that we didn't get into this predicament in a day, and we're not going to get out in a day. And anything that sounds too good to be true in terms of some side deal probably is. And so there should be some patience. People should be taking this seriously, but they shouldn't be freaking out either. The sun still comes up in the morning, goes down at night. And we're gonna work through all this. It's just going to take a bit of time and effort. And on your last point about the importance of open discussion, I couldn't agree more. There's a reason why the words truth and reconciliation are always spoken together, and you need to have true and honest discussion. And that doesn't mean people have to always agree, but we should absolutely respect that Aboriginal rights are constitutionally protected in Canada, one of the few countries in the world. But that doesn't mean that they're limitless and there's not other interests at stake. And the courts have been very clear in recognizing that so far, and I expect they will in due course here.
Closing thought from you, Radha?
Yeah, I agree. I would say that the Constitution may provide the tools and the answer to how we deal with this. And I also agree that we have to continue the discussion. The public discourse has to continue. There's not going to be like a simple solution like next day. But when you have a situation where people from under them who was living with certainty of title, all of a sudden it's somebody plays with it and takes it away. It is staggering. And so as a result, I agree with Robin. I mean, no one is coming, like that's what the Cowichan people have said and the lawyers have said. We're not going to be looking at taking away people's home at this stage or anything like that. But what does it mean right now? What does it mean in terms of how do you plan? How do you expand? How do you grow? How do you do all these things when you have the Aboriginal title that is a senior interest? And so those are the kind of questions that will continue to fuel discussion in British Columbia, and it's not just a Richmond issue.
No, it's
not.
Yes.
If I may just add, the reality of all this, the client that we represent, have plans to develop a significant building, employing hundreds of people, spending millions of dollars. That's not happening now, and they've been told by various lenders and banks, we're just not going to invest there. You've seen at that Richmond town hall meeting people saying that they're having trouble with their banks. This is real. This is not esoteric. This is not legalistic. It's not philosophical. It's affecting people's lives today.
Yeah, and that's why the application by our client to get in and put evidence in is important, because now we see the evidence of this. Like, as time grows, there will be more and more evidence of these type of situations, of people not wanting to invest here, not wanting to grow, and all of those things, or people having issues. So with the passage of time, that will be shown. And what we're trying to do with our client is trying to do is put it in front of the court now.
Well, I remember when Delgamuukw was decision came down, it put a tremendous chill on investment in British Columbia, and over time, that case was not seen to be as significant in the way in which it would impact business decisions. The Cowichan case, I think, is a completely different game changer, and I think it's right. We have to watch very carefully what's going to unfold here in the coming months and in the years to come. Thank you for giving us a little bit insight here into the complexity of this, but also what's being done to try and find an agreement or a path forward that respects everybody, everybody's rights. Thank you.
Thank you.